just wrote an article. It's going to be coming out soon with a good friend and colleague, former colleague at Missouri, one named Jean Sternlight. She now is at the University of Nevada, Las Vegas, where she's the director of their Dispute Resolution Center. And it's about using ADR to incorporate it more in legal education. And it kind of relates to a piece that Michael Moffat wrote. This is part of a symposium issue that will be coming out soon. And he described 4 different models of ADR education that law schools could use. And he has these wonderful metaphors for them. One is salt, where you would kind of put some salt, and the law schools would plan to sort of put some salt, a little ADR in a number of different courses, but not necessarily have a single standalone course. Vitamins, where you have a single course where you make sure that everybody has at least one vitamin, or an island where you have an island of excellence, and there are a handful, 10, 20 law schools that really focus on ADR. And then a 4th model is what he calls germs, which is where you have law faculty who incorporate ADR concepts in their teaching of various doctrinal courses. So Michael and Jean teach civil procedure. So when they teach civil procedure, there are various ways, just in the normal course of their civil procedure courses, to incorporate some ideas of, for example, looking at the client's interests as well as what the legal rights are. I mean, there are a variety of things of doing that. So this article that Jean and I have written basically is following up on the germ theory that Michael has focused on, because there are real structural barriers to making curricular changes in law schools that are just really huge. A law professor, we value our independence, academic freedom, prize that a lot. And it's really following the logic of interest-based negotiation. It's trying to say, okay, if this is something that you're interested in, and many faculty are, and if it's something that's not going to be too difficult for you to do, because faculty are under pressure to do a lot of things, mostly to write law review articles, and teaching is not necessarily high on their list. So if there's something we can do to help them do something they'd like to do that isn't going to take a lot of time and effort and distract them from other things that they're committed to do, then we're hoping that will have some impact. And some schools are willing to make some of these shifts, but as an institutional decision, but lots of them aren't. And so one of the things that Jean and I are talking about with the ABA section of dispute resolution is to have a project to provide technical assistance and develop resources to help ADR faculty assist their colleagues in their own law schools to incorporate germs in their teaching. So if you have someone who teaches property or contracts or civil procedure or a skills course, a clinic course, any other course, to provide materials and ideas about how they can incorporate some of these things into their education, which to me is important, actually in some ways a lot more important than having these standalone courses, which I teach and I think are very valuable. Part of it is that the way the curriculum is structured now, even with the salt or the vitamins, is that it makes it seem as if ADR is this ghetto, this sort of separate, isolated thing, and it's an either-or thing, and it's this sort of oddball thing, whereas in real life of what lawyers do every day, they negotiate, and many of them mediate, and many of them arbitrate as advocates. I'm not talking about acting as neutrals in these processes, and they need to be thinking about how they approach practice in that way. And unfortunately, the message, as I mentioned before, that's sort of implicit and just repeated incessantly in the way law school education is, with the Socratic method, using these case books based on excerpts of appellate litigation, the implicit and powerful repeated message is what law is about is appellate litigation and understanding what these rules are. And again, those are important elements, but in terms of what practicing lawyers do, most practicing lawyers do every day, rarely in litigation as a proportion of the practicing bar, and also, very few trials even. I mean, most things are settled. So that's a mission that I'm actually about to start. There's going to be a session at the ABA section of dispute resolution conference in April that Jean and I are going to be on a panel of, and we're hoping actually to develop a little project through the ABA. We're still talking with them about how that might be. So that's one of the things that I'm interested in doing is getting this incorporated, sort of much like Daniel Ellsberg, sort of internally through the system.